Everyone, and thank you for in today's Saturday morning session by our GST faculty group, wherein we have been taking this initiative of discussing section by section, and we have the proud privilege of having a lot of wonderful speakers in our group, and in fact, the best speakers across India in our group. So we are taking full advantage of that, and we are requesting the speakers to put in their resources and time to share their knowledge on specific topics, wherein we are getting clarified about some of the issues, and we are also having a lot of thoughts, which we have seen in the last few sessions. So today we have with us C.S. Subramanian PS, fondly known as Supuji from Bangalore. He is taking an active role in Karnataka Chartered Accountant Station, State Chartered Accountant Station. So he is playing their very active role in dissemination of knowledge on the front of GST. And we really congratulate him for that wonderful role that he's playing. Apart from that, he's helping a lot of clients on the direct tax front through advisory, through litigation and compliances also. So, with this brief introduction, since we have already taken up 1 minute of his time, so I have not taken further time. So I would request Subbuji to take over the session.
Thank you, sir. Very good morning, everyone. I would like to thank the organizers for our team of organizers, very active and involving and supportive. So thank you for organizing. Thank you all for joining today. So today's discussion, I'll just share my presentation. Yeah. So section 11. So the agenda for the discussion is the basics of section 11, where I've tried to list down few points to dissect the section 11 and see what is that we can gather from the wordings which is used in section 11. Section 11, as we know, has 3 subsections and a proviso. So what each of it has to convey, the placing of the words and the usage of the words, we'll try to share my thoughts, maybe wherever needed. I'm sure we have a lot of things to take back, and I have a lot of things to take back in this involving session. Next is on the definition of exempt supply. There are a few judgments which speak about whether the exemption entries are to be strictly interpreted or liberally interpreted, the applicability or otherwise of an exemption entry, the wordings used in the exemption entry from the earlier judgments in the context of service tax. I've tried to list down a few which could be relevant in the context of GST. That also we will go through once, and a few case studies which will help us to connect to the contents of section 11, as in whether the maybe whenever we have to whenever we are encountering a situation to address whether something is exempted or not. So the essentials of section 11 has to be tested. So few couple of case studies we can also I've also listed, so which we can go through. So this is section 11. I will not read it because whenever needed we can come back to this, but essentially, so 11.1 is on the, as we know, it is the general exemption. General exemption, as in the general exemption could be either absolute exemption or conditional exemption. So which has to be issued in the interest of public by the so which has to be in the interest of the public. It should have been issued by the government and on the recommendation of the council. So if we closely see this, it clearly covers even a situation where a partial exemption is given, is also issued under section 711. So here it clearly says whole or any part of the taxable tax leviable thereon. And 11.2 is on the orders which are issued under 11.2 exempting, given the fact, the specific nature and circumstance of the situation, which could be the reason, and the reason for such exceptional nature has to be recorded in the order, that is 11.2. And 11.3 is on the sunset clause for the government to issue the clarification in relation to any ambiguity that may exist in the exemption entries that have been notified. There is a period of 1 year which they have stated, within which such explanation can be inserted. So as I saw, there were about 3 explanations which were inserted by virtue of 11 subsection 3 in that 1 year period. So this basically has a retrospective implication, as they say very clearly in 11 subsection 3. And the explanation is also quite interesting. So here the point here is explanation: for the purpose of this subsection, where an exemption in respect of any goods or services from the whole or part of the tax leviable thereof has been granted absolutely. So as we saw, it is concerning only 11.1 and not 11.2, the explanation. And when it comes to okay, sorry, it covers either both 11.1 and 2, but the exemption should have been granted absolutely without any conditions. Then the registered person shall not collect tax in excess of the effective rate on such supply of goods, is what the provision says, and it is only for the absolute exemption. This is the structure. Maybe we will dwell into each and every relevant points in this and see what we can gather from the wordings here. So the choice of words, I was reading numerous times. The choice of the word is that they use the word satisfied. So if you see this, where the government is satisfied that it is necessary in the public interest so to do. So the necessity that has got created should be very clearly visible in the entry which is there, or the exemption which is given is the requirement. And when I also compared the exemption entries in the context of the exemption section in the context of service tax and central excise, the same words satisfied is used. So it is not saying or of a view or in opinion of the government. It is saying satisfied. So I think that is something more than those terms, and satisfied should be beyond. But I was thinking, where will this particular satisfaction be understood? Like, where is it said, or somewhere is there any record to say that the government is really satisfied with the need? So maybe GST Council discussion is something. So as I could sense from section 11.1, there are 2 things separate. The government is separate and the GST Council is separate. The recommendation, based on the recommendation, the government has to be satisfied, is what they say. So nowhere else we find the fact or the aspect that the government is satisfied with respect to an exemption entry. The only place we see is in the initial para of all the sections, where they say the government having been satisfied in public interest so to do, they have exempted these entries, is what they say. So apart from that, I don't see anywhere else the word satisfied having been used. So we'll have to see if the word satisfied can be used probably in the courts to see whether there was really a satisfaction or not for a particular exemption or otherwise. So that is one thing I wanted to share. Next is recommendation or satisfaction, which comes first? What do you feel? Recommendation from GST Council is first, or satisfaction from the government is first? What do you feel? Anyone? So if you go back to these wordings, where the government is satisfied that it is necessary interest, that is necessary in the public interest so to do, it may on the recommendation of the council by notification exempt generally. So it goes on from there. So what do you feel, whether the where the government is satisfied is what it starts with, and it goes on to say it may on the recommendation of the council. So what do you feel is first? Is the recommendation from the GST Council first, or the satisfaction by the government is first?
Practically, I think the recommendation by the council is first. So that's how it happened.
Okay.
As we have seen from historically that, the council is actually, the fitment committee is evaluating whether exemption should be given basis our request from the trade. And then the fitment committee is requesting the council to take up the decision accordingly. And then council is recommending, and then we are seeing the notifications coming in when the government is satisfied. There is no exemption.
That's right.
So this is my view.
Yes. Anyone else having any different thought or agreeing to Arup sir's thought?
Yeah, Subramania, I am of the opinion that, the council should make sure that it falls within the satisfaction or the framework of directive principles of state policy before even recommending.
Okay.
The government to ultimately at the end is, it is only confirming. Satisfaction is nothing but the confirmation of the recommendations of the GST council.
But interestingly, ma'am, I've also come across a situation, maybe if you have noted, in the initial portion, when the GST Council update was being given by way of a press release, we saw a situation. I'm not sure if my memory serves right, but maybe someone can correct. In the initial few months, there was a rate entry which reduced the parts of motor vehicles from 28 to 18 as per the GST Council meeting outcome. But never the notification came. It still is even today at 28. Anyone came across this situation? Because it was quite some time before. So that was a classic situation where the GST Council has recommended, but the notification was not issued by the government. So I'm not sure if there are any other situations like this where some recommendation is there from the fitment committee and as per the minutes of the meeting, but finally either the rate reduction or the exemption entry was not in place. And coming to the rate reduction, why we are speaking about rate reduction in the exemption? So very clearly, as we see from section 11, subsection 1, the last 3 lines of any specified description from the whole or any part of the tax leviable thereon. So even a partial exemption, in case if it is there, that could also be covered under 11 subsection 1. And as we know, notification 11/2017, which speaks about rate, apart from having been issued under the powers of section 9 subsection 1, is also issued under the powers of 11 subsection 1 and few other sections. So I think we still have to refer back to section 11 subsection 1, even though we are reading the rate entry. That is what is my view on this. And coming to the point on whether the government satisfaction is first or the recommendation of the GST Council is first, I read this multiple times, 11 subsection 1. So even if we just attempt to read this, maybe we will read this together, where the government is satisfied that it is necessary in the public interest so to do, it may, on the recommendation of the council, by notification, exempt generally, either absolutely or subject to such conditions as may be specified therein. And it goes on. So I feel wordings wise, it says the government is satisfied that it is necessary in the public interest so to do. It may, if we skip the next wordings, it may, by notification, exempt generally or absolutely. So if the practically what is happening is right, and if we also trace this to Article 279A of the Constitution on the functions and the formation of the GST Council. So in the responsibilities that the GST Council handles, it very clearly says recommendations to the government on the rate and other things is mentioned. So essentially, I feel the practice as well as the Constitution says that it has to recommend to the government for its implementation. So obviously the recommendation should come first, and then the government's satisfaction, and then the issue of notification. That should be ideal. But I think this probably is more about playing with English, I feel, because 11 subsection 1 is so worded. If it would have been very clear, if it started to say, based on the recommendation of the council, if the government is satisfied, it may by notification exempt generally. That would have been, I don't know if that would have been more ideal. Maybe I'll just pause for a minute here to take views from anyone else in case if they have any other view. Yes, we know practically that is how it is working. 279A clear, and first the recommendation comes, then the government's notification. That is how it is happening as well. But only the wordings appears that it is slightly in a different way, or maybe the English has to be read so that on recommendation of the council should have got placed before it may. That is what I feel. So I'll go to the next portion. So general exemption, it could be absolute or conditional. So absolute, as we know, it is without any conditions attached. It is plain. Conditional is with the conditional clauses or the conditions specifically mentioned in the notification itself. So now the issue that always we had, even in the context of central excise, is can you forego an absolute exemption and charge taxes? Or can you forego a conditional exemption and charge taxes? This was always a point which was there. To this, I think this explanation may probably come to our rescue. If we see this, for the purpose of this subsection, for the purpose of this section, where the exemption in respect of any goods or services or both from the whole or part of the tax leviable thereon has been granted absolutely, the registered person supplying such goods or services or both shall not collect the tax in excess of the effective rate on such supply of goods or services or both. So this explanation very clearly says that in the context of the exemptions which are absolute in nature, the registered person shall not collect the tax in excess of the effective rate on such supply of goods or services or both. So this clearly says no excess collection of tax. But what in case there are two entries in the exemption notification, or there are two entries in the rate notification which also has a mention about 11 subsection 1, with one of it at a particular rate and the other at a different rate. So will it be an option for us to go for the higher rate, collect such excess tax? If you compare that, apropos the first entry, which is having a lesser rate with a condition. So can we probably see and come out with a proposition that since the exemption is not absolute, can this clause be interpreted? So the example that we have, of course, is on the restaurant industry. So the restaurant industry, the rate of tax is 5%. And there is a clear explanation saying that if the nature of service is so, then you can't come under the residuary category. You have to charge the tax under the main category. And as we know, in the notification 11 against the restaurant entry, there's a clear indication about the condition and the reference to explanation 4, which talks about considering the transaction as exempted for the purpose of ITC reversal. All of that is there. So can we say that though the notification says the act is not specifically restricting the conditional notifications, conditional entries is one thing which is something which I think should be further thought about and discussed. Anyone has any thought on this part, where the exemption is not absolute, but still is there any scope for us to choose between the entries and go for a higher rate with the claim of input tax credit?
I think we have to look into strictly actually. If it is a conditional exemption, it has to be read strictly. You don't have that option of either absolute rate or a conditional rate. So if it is a condition, we are obliged by that conditional exemption. So according to me, you cannot have choice of absolute and conditional.
I agree, ma'am. But as you know, there are a few judgments in the past where it says if there are two entries which are applicable to a particular assessee, he can choose whichever is more beneficial to him. But the only thing is that he should comply with the points, or he should get covered in that particular entry. I've listed that as well. We will go through, but I feel considering the Supreme Court judgment, which is there even in that regard, I am not sure in case if we have to consider this still an open option for us to see if this is still there, because the act is restricting only to the extent of absolute exemption. One more issue that I see in whatever I am saying is the explanation speaks about the last but one line speaks about shall not collect the tax in excess of the effective rate. So is it speaking only about a situation where there are no dual entries and there is a reduced rate and you are charging something more? Or is it also talking about two entries which could be there in the context of a particular exemption. So just for an example, maybe I'll just go to that particular slide. Okay, in the context of the rent-a-cab services, so there is one entry which talks about passenger transportation services where the cost of fuel is included. There the rate of tax is 5% with the credit being allowed in the similar line of business. But there is a similar entry which is speaking about renting of a motor vehicle where the similar line of business credit is missing. This is there for this particular entry. So can I choose between these two and go for a beneficial one is one more thing that we have to probably look at here. Maybe those judgments where it is discussed on this is also something which I have noted. We will go there. Once we go there, we will discuss.
Sir, one more point, sir. Just one more point I want to make, sir.
Yeah.
Sir, if you see the last but line, it says about shall not collect the tax.
Correct.
There is one issue which I had faced, which is regarding to RCM. So RCM 9.4 up to 2019, there was one exemption.
That's right.
Earlier, it was 5,000 and it was absolute exemption, etc.
That's right.
So there I have taken a view that this explanation does not apply to RCM because there is never situation where I am collecting the taxes.
That's right.
So I have taken an argument that it is optional. I mean, claiming the exemption is optional. And if I'm paying RCM, I am eligible to take the credit.
So that's where again, you feel that it is not an absolute exemption. More than anything, there is the clause itself will not apply because it is not a case where you're required.
Correct. I'm collecting the
taxes.
taxes. Correct. I'm not collecting the taxes there.
That's right. Since you have foregone the exemption which is available, yes, I think that is a good example or good situation that you have brought to our note, everyone's notice. So I think that is one more stand probably to look at and defend in cases where they have denied the ITC, even in a case where you have paid the reverse charge.
So there are a couple of judgments also which says that exempt from levy and exempt levy are both different.
Sorry, can you come again? Exempted?
Exempt from levy and exempt levy itself is different situation.
Oh,
so where the levy itself is not there, then there is a question of whether credit is available or not. But when there is a levy under section 9 and then an exemption is given under 11, then and if I'm not claiming that exemption, then probably I can say that the tax which I have paid is valid.
Maybe can you give an example in case if you have further thought about this for these two parallels, just for everyone's benefit?
It's the same situation, sir. For example, if you take the example of petroleum or some other products which are not under the levy itself, there if I am paying taxes, then the amount I am paying itself does not have the character of tax.
That's right.
Whereas the RCM, there is a valid levy under 9.4, but an exemption was granted under 11. So there I am not claiming the exemption.
Understood.
So the levy itself cannot be questioned there, or the tax amount, the character of the tax cannot be questioned there. It is a very much a tax because there was a levy.
Yes. Agreed, sir.
Subbu, I have one more point.
Yes.
When we read this conditional notification, it cannot be said it is absolute exemption. Take of example under the restaurant services which you are talking about.
Correct.
What if I have paid tax under the 5 rate or concessional rate or exempted rate, but I have still availed the input tax credit? What would be the scenario in that case? Would the department would say you have not fulfilled the condition and hence you are liable to a higher rate of tax? Or would they demand it under the input tax credit wrongly availed and paid the taxes? In my view, the correct view, if you have not fulfilled the condition, you are liable to pay on a higher rate. Since you are liable to pay the higher rate, then you should claim the, you can pay the higher rate of tax. There is no compulsion on you to opt the exemption notification. That is my view. So I slightly beg to differ with the Kabra ma'am saying that it is an absolute conditional, absolute notification. You don't have a choice. I still feel that we still have a choice because the exemption is not absolute exemption.
That's right. And interestingly, all of this revolves around the fact that even the notification, rate notification 11/2017 also has a reference of section 11, which means in a way it is a reduction in the effective rate of tax, partial exemption in case if we have to consider that way. So considering that, I think the interpretation or the discussion of 11.1 along with the explanation should be probably extrapolated and could be considered even for a rate notification is my take. So, but when it comes to your specific point, Nilesh, so since this particular, we actually take a position, right? So we say ours is a restaurant service and we are going for 5%. I believe there are a few judgments which say that once you have taken the benefit of a particular entry, you are bound to comply with the conditions. If the conditions are not satisfied is the question now. Now, I feel they may probably enforce the conditions to be satisfied. So rather than, and also considering the fact that if you see this situation from the department side, they may always want to deny the input tax credit rather than demanding the higher rate of tax, because if they are going for a higher rate of tax, their notice itself will not be valid because it is going against the very condition in the notification which asks you to go back to the same entry of 5% when it comes to restaurant service. But otherwise than this particular example of restaurant service, I feel if the exemption is not an absolute one, and if it is a conditional one, you are not getting covered under the explanation of section 11. And I think there is a possibility that you may still have an option to choose the residuary entry, is what is my opinion, and also an entry which is more beneficial to you. As I gave an example of passenger transportation service versus the rent-a-cab services, where the line of difference is very thin, and the beneficial entry of for the assessee could actually be chosen.
Subbu, but under the service tax regime, if I'm not wrong, there were many judgments which says that if you are not fulfill the conditions of the notification, exemption notification, then you are not eligible to avail the exemption. So they are going back to the, then you are, if you are not available for the notification, exemption notification, you are liable to pay the higher rate of tax.
Yes, the reason why
this will be the difficult in a GST scenario.
No, the reason I feel it was so in service tax is section 66B prescribed one rate. So if you are not complying with the exemption, then the rate applicable under section 66B should apply. As against the context of GST, where the reference is to the notification. So maybe the facts are slightly different. A little more study is required even from my side, probably to more certainly give a conclusion on this, but I'm here to just get the perspectives and take the thoughts here.
I think in 66B there is no specific rate, but they have kept a cap on in a 66B. They're not exceeding so much rate, so there is no specific rate in Finance Act 66B. It is a cap basically that has been provided.
Is it, sir?
No, I think the tax should be charged at the rate of 12%.
That's what even I remember. Maybe I'll just open it so that it will be easier.
One more point, Subbu, with respect to what if there is a rate notification, I have provided the condition input tax credit has not been availed. If I have said I have not fulfilled the exemption notification, means I am not fitting into that entry, and there is no other specific entries available for that purposes. Since the rate has not been specified, the services are not itself is taxable.
That's
right. Some weird kind of scenario, but that's what I'm trying to.
So I think here it prescribes, sir, there shall be levied at a rate of 14% on the value of services. So that is what I was trying to see. There is a difference in the structure or the placing or the rate mentioned. In GST, we have a higher rate, and it refers to the it asks us to refer to the notification and then conclude on the rate. So that is one thing. And exemption, can it be wholly or partly? Yes, exemption is wholly or partly, very clearly there. But if you see this clause 2, 11 subsection 2, sorry, here it reads where the government is satisfied that it is necessary in the public interest. Paul Tangam, sir. Yes, sir. You had something to say, sir.
I mean, audible, sir?
Yes, sir. You're audible, sir. Please.
Yes, sir. Sir, regarding that hotel restaurant services, see there is a specific entry, sir. Explanation is given for item number. That is for you cannot charge 18%. There they are given for the removal of doubts. it is hereby clarified supply is covered under 2, that is specifying rate of tax at 2%, 2.5, shall attract central tax prescribed against this item and not under this entry. So by foregoing this condition and by taking the ITC, you cannot charge your rate, I think, sir. Only if you are from a specified premises, you will be coming under that 18% category. Otherwise, by foregoing some of the conditions, you cannot opt for ITC and also charge higher rate, sir. This is my opinion, sir.
Yes, sir. Sir, because
Because
yes,
that is a experience.
Yes, sir. Agreed, sir. Now, this notification, as I mentioned in my presentation as well, is clearly mentioning this particular condition that you have to go for this rate and you can't go for any other rate under this particular entry. As in, if you see the positioning of the entry, the last entry is any other services of accommodation, restaurant, and the other residuary entry where the rate is 9%. So against that particular entry, which is the residuary entry under accommodation and hotel and restaurant related activity, they clearly say, as you rightly pointed out, it clearly says that you can't go for this entry and you have to go for the above entry, very clearly there. And I think that is amendment which got applicable, which got inserted a little later. But I'm only referring to this explanation, sir. If you see this explanation and read it together along with me, for the purpose of this section, where an exemption is in respect of any goods or services or both, from the whole or part of the tax leviable thereon, has been granted absolutely. The registered person supplying the goods or services or both shall not collect the tax in excess of the effective rate. Now, 2-3 things in this. It is talking about the exemption in respect of goods or services, whether whole or part. The first point here is, can we say the government notifying 5% rate for the restaurant sector, of course, with a condition, can it be called as an exemption to the part of tax? Now, the issue is, to this, I feel yes, because if you see the rate notification 11/2017, it is issued both under the powers of 9 subsection 1 and 11 subsection 1. So it is clearly a case where the exemption, where I think even 5% rate for restaurant sector is also a partial exemption to my view. Maybe I'm, if anyone else has any different view, I'm okay to take. Yeah.
May I add something?
Yes, sir.
Actually, if you see the VAT laws, earlier VAT laws, there were a list of exempted goods and then there
Schedules.
was a good list of taxable goods.
Correct, sir.
Schedules. So the schedule, exempted schedule was a different. But if you see the GST structure, the section 11 compromises of both the schedule of exempted as well as the schedule as well of taxable goods and the effective rate. It tries to reduce the section 11 tries to reduce the effective rate of the taxable goods. Now, if you see the exempted goods, then the Govind Saran judgment will be applicable where it is a wholly exempt, where there is no trade, then there is no tax. And in that context, we have to see that section 11, it is an exempted goods, we cannot collect any tax. Remainder schedule will also not be applicable. But when it comes to a specific exemption or a partial exemption, then or one of the activities or one of the transaction in the series of transaction is exempted, then probably that Supreme Court judgment of A Infrastructure was the state of Rajasthan, where it says even if one of the series of the exemption series of transaction is exempted, the goods are still taxable and hence ITC will be allowed in the subsequent stages. So, so in my opinion, the section 11 is a mix of exempted as well as providing an effective rate. So these first we have to segregate and understand where the goods fall, whether the goods or services fall under exempted or it is on the partial. And accordingly, the treatment and the legacy jurisprudence on this has to be applied in that fashion. That is
so in that situation, specifically for this particular point of restaurant, do you feel the restaurant rate specifying 5%, is it not also under the power of section 11(1) it is notified?
Yes, section 11, I think section 11, but we have to see whether the restaurant, if suppose the full rate is tariff is given, can we say the restaurant's full tariff is there of 18%?
I'll open the entry, sir. I'll open the entry.
Subbu, I have a small query. It could be very stupid, but just let me ask. how do we presume that this is an exercise of 11.1? Can I just say that it is merely an exercise of 9.1 read with 16.1? I'm specifying a rate under 9.1. I'm attaching a condition under 16.1. Why is there a requirement that we need to think it as an exercise of an exemption notification?
I had the same doubt. So I just referred the very first notification, as in without amendments, the first notification 11/2017. Right from there, the notification is having that clause. As in, I'll just open the.
Yeah, Subbu, I will just add to the Unni's. The reason for the exemption notification under the levy section 9, the power has been given only to prescribe a rate. There is no power to prescribe any condition to the rate. So the rate can be specified in that section only. There is no power to put the condition to the rate. That's why the abundant caution, they have inserted the section 11. And because since section 11 is there, it's under the cover the exemption notification. That's what I read it.
Yes, I think even I, in a way, agree to your view, because I think the government had to safeguard that there is no ambiguity in the notification, rate notification itself. As an abundant caution, I feel they have referred 9.1 as well as 11.1 in the context of the notification 11/2017, the original notification 28 June 1. So I feel in a way, since the rates which are there up to the maximum of 28 is what they say it can be notified. So I think even the 11 bar notification is in a way governed by section 11 subsection 1 because of its specific reference. Till yesterday, I was of a understanding that this 11/1 came into picture only when the real estate changes happened from 1st April 2019, because we had a lot of discussion even in our group that 3/2019 had a explanation or a addition inserted in the initial paragraph, and it got changed right from there. So I was always of an assumption that this 15.5 reference and 11.1 reference only was from 1st April 2019. But when I was reading this yesterday, I actually clarified it for myself that this clause of 11.1 is there right from the beginning. Now coming to Unniji's question, should we read this into that? Now it again depends on the context. If we have to probably face a litigation and probably is a case where you have gone for a beneficial entry, I think you may have to stick to this particular view, I feel. But the only purpose I could sense, maybe anyone could further add to this, of having this 11.1 is only that to give an abundant caution that wherever the rates are reduced, even that is right. For example, though we understand that generally the services rate is 18, that is the principle with which we are going, but actually speaking, service rate is rate as notified. So the general assumption is 18, anything less than 18 is a reduction. So that is how we have thought about, but yes, I think it is as per the rate notification, that is what we have to see. And the entire discussion here is coming only because 11.1 is referred in 11/17. I'm sure I have not answered your question, Uniji, but I feel that is the response I have.
Subbu, okay. So why do we call it as a partial exemption? The 5%, just because we have one 18% and 5% for the same HSN, is that your basis to define?
No,
that
I'm not saying it is partial exemption, sir. I'm saying it is not an absolute exemption. So if you read this explanation for the purpose of this section, where the exemption in respect of any goods or services or both from the whole or part of the tax leviable thereon has been granted absolutely.
Correct.
So the tax cannot be, the registered person supplying the goods shall not collect the tax in excess of the effective rate on the supply of goods or services or both. Now, correct. What is the effective rate and what is the excess collection is the issue. I am not referring to whole or part. I am referring to this absolute exemption. So
no,
if you
saying that it is not absolute exemption is right, but saying that it is partial exemption is not right.
No, I'm not saying partial exemption, sir.
No, because for 5% you said, can we not say it as a 5% partial exemption?
No, sir. Maybe I have missed it, but the point here was for restaurant activity, since there is a condition attached specifically in the entry saying that you have to refer explanation 4 and other things. It is, I feel, maybe if anyone still feels that it is absolute, they can come in, but I feel it is conditional. So
Got it.
once it
Does
is
the
conditional,
condition draw power from 11.1 or 16.1?
sorry,
Does the condition draw power from 11.1 or 16.1?
it should be from
Because
11.1.
11/17 also refers to 16. So ITC restrictions and safeguards are also inbuilt into the rate notification. So can I not take a stance that I prescribe the rate, as Nilesh sir said, we cannot attach conditions. So I prescribe a rate at a 9.1, and conjoined with that, I invoke the 16.1 to say I am not going to grant you ITC for this specific classification and rate.
So you mean to say the condition which is flowing on the ITC is probably on account of section 16 and not on account of section 11.
No, I'm asking why could we not take such a position and need to drag in 11.1 for this?
So if you see any other exemption conditions for that matter, do you feel, okay, maybe there are few exemption notification, let's say the subcontractor exemption, there is a specific exemption which is not, the condition is not talking about the input tax credit part, but it is talking more about the subcontract as is basis and a portion of contract. If you see in the context of subcontract for government works, yes, I think there are a few meetings. So there are a few situations, probably the conditions, as you rightly said, maybe it is flowing from section 16.1. Maybe if that is the case, then okay, let me just open the entry itself so that if there are any other clauses in the entry, we will be.
Oh, even for 3/19, that rate notification not only decides upon ITC, but also attaches condition as to number of quantity of percentage that we require from registered persons and so on and so forth.
That's right. So it says provided the input tax credit charged on goods and services used in supplying the service has not been taken. So if you read section 16.1, does it give any scope for a condition to be notified on non-eligibility to claim? Because if you say the power for section 16 has to flow from here, as in the restriction is more akin to section 16 or connected to section 16 rather than section 11, the exemption notification, I don't see any of the clauses in section 16 which says the rate can come with a prescription on. There is no scope for prescription in section 16, I believe.
16.1 talks about conditions and restrictions as prescribed in the manner specified, be entitled to take. So at the time of entitlement itself, I am eligible to attach conditions and restrictions. So I am using it in parallel with 9.1, saying that if you are going as a person who are going to classify your services in so and so manner, and you've chosen the rate applicable under 9.1 as so and so, this is a condition or a restriction which will prevent me from taking a credit. So doesn't 16.1 give a larger shield to the government to notify a rate notification with a condition to make a partial claim or a non-claim of ITC?
I think yes, that is also a possibility. But yes, it is again reading in.
Subbu, basic question: is the rate notification also prescribe the section 16 reference?
Yes. Okay. This is the rate notification. It even covers section 16.1.
Okay, we are only seeing your PPT.
Oh, okay. So I was actually reading this.
Yeah, it would be great if that notification again also.
I think I had to share the entire screen. I was reading.
Yeah.
So this is 11, and it says it is 11 subsection 1, 15.5 subsection 16.1. As Uni rightly pointed out, as may be prescribed in this manner, and the manner specified in section 49 is what it says. So yes, I think now tracing the entries, description and conditions to which of these sections referred is something which probably we have to see. But yes,
this 11 also has somewhere in between, I remember, nil.
Yes, sir. 11 has one of the entries as nil. Correct.
Nil. Because of that, we still need to add that 11. Can we not say this power of 11 was required to notify that nil?
Probably, sir. But yeah, that is also a possibility. Yes, there is one entry which says nil or yeah, this one.
9986.
7-2 also.
Yeah, 7-2 also. 16.
And agriculture leasing, I think, also is somewhere.
Agricultural services.
So is it exemption or nil rating?
Yeah,
Section
but
11 gives the
still
power to
power has
exempt
to be
wholly
drawn
or
from
partly. It is not nil. So the reference to exempt supply definition are section 11. Does it even talk about nil rating?
Yes.
11 includes nil.
Which attracts nil rate of tax, the first limb.
First.
Okay, fine. So I think yes. So the point I wanted to bring it to the discussion is that is there any scope still available for us to say that the restriction in this are we seeing the PPT?
Yeah, yes, PPT.
Okay. So the point I wanted to probably bring out for discussion or maybe for a little more thought is basically that can this explanation, which is part of the act, which restricts only the absolute exemption entries from choosing or going for a higher rate, which means the converse of it being that any other exemption entry which is not an absolute one, can you still go for a rate which you want to choose? So this is what I probably once the litigation on
can you rephrase this, Subbu? It was a little confusing for me.
So the explanation here in section 11, the act is only concerning the absolute entries, absolute exemption entries without any conditions. So probably can we say that if there are any conditional exemptions, this explanation should not apply? If this explanation should not apply, there is no harm in choosing another entry which is giving the higher effective rate of tax. One way to look at it.
Do we have that right to violate a condition and go for a tax rate when there is an exemption? Is there?
Sir, except restaurant, no other place it specifically says there, right, sir? Except restaurant.
Restaurant, correct.
It's there for 3/19 also.
That's right. So 1E, 1F, once you are going there, you have to go under this. Yes. So except in those instances, and even, so my point is specifically in relation to those instances, in fact. So restaurant, they say it is conditional, and they say the notification says it is only restricted to that particular entry. You should not go to the residuary entry is what it says. But the concept of charging higher rate is restricted only for those which are absolutely exempted. So in a way, did the section 11(1) explanation give way for other entries which are not absolute exemption, an inherent right in the act itself to charge a higher rate and go for a other entry, residuary entry, rather than going for the entry with condition, though the notification says in a couple of contexts that you have to opt this particular entry? Is that clause which is there in the exemption entry which asks you in the context of restaurant and real estate to opt only that rate, is it in contradiction to the explanation in 11? Can we read it that way? Is one thought that I wanted to share.
Can you give me an example, sir?
That's what. So I spoke about this rent-a-cab related thing where there are two rates, but again, the rate is not higher there. Okay, maybe. So you are basically looking for an example where the rate is higher and you can go for a residuary entry, right?
Yes.
I do not have it readily, but I think there should be something which we should see from both 11 and 12. I can see and come back.
Subbu, can we not say this way? See, when 3/2019 notification is issued, since it is a continuation to 11, given that it is continuation to 11, the preamble of the 11, where the powers which have been drawn, that has been kept intact. And since it is an addition to it, so they had to take the additional power under 148. So all those have been retained. So 3 should not be read specifically saying that section 11 powers were required for 3.
Possible, sir, but I think by end of the day, that is what I said. For which entry, for which rate, for which condition should we trace it to these clauses is something which we are not sure. As
Yeah, agreed. See, I have
Right.
also never read
Yeah.
this in this, looked into these lines, but yeah, I'm also parallel
So as
expert.
Uniji also rightly said, probably the ITC restriction conditions are probably drawn from section 16.1 rather than 11.1.
Correct.
So exemption can be okay. Can the exemption be from an earlier date?
Yeah, sorry, one point. When for the partly, the 40/2017, can we say that is like a partly exemption?
That is in fact is issued under 11.1 only, right, sir?
So that's what whenever we say wholly and partly, the partly would be exemptions.
There are many rights, sir. For example, lot of instances where the DRDO supplies and the research supplies, that's, I think all of that is partial exemption only.
Yeah.
So there very clearly it appears, because there is one rate notification which specifies that particular for entry, and based on the usage or the recipient or the supplier, they have specifically issued a notification saying that the rate in excess of this rate will be exempted. So that is clearly a partial exemption. So it would have been, I think the entire discussion would not have come up at all in case if the first notification 11/2017 did not have the reference to 11 subsection 1. That was my point, because I think so right from the beginning, I think the screen was not visible, I believe. So now is it visible, sir? I mean the PDF?
Yes, it's visible. Notification.
So here, this is 28th June notification. Right from here, the reference to all these sections are in place.
Yes,
So I think this probably could be the reason that we may have to reconsider in case if it comes to our rescue at the time of any litigation on addressing the matters where a different rate is chosen. I did not get a chance to do a detailed reading even on the recent judgment of the judgment where the 1/3 deduction was said to be optional, as in the judgment. I'm not able to recollect the. I did not.
Manish Munjal Bhai Bhatt.
Yes, Munjal. So can we probably? I'm not sure if one of these discussions is also part of the arguments taken. Probably, maybe I'll just go through once again and then see in case if this is one of the arguments that are probably taken ahead in that particular case as well, because even that draws the power from 11.1.
Yeah, this argument was taken.
It was taken, is it, sir? Okay.
Yeah, yeah.
So I think yes, whatever we are discussing has some probably application sometime. So next is, can the exemption be from an earlier date? So the exemption can be from earlier date, because if you see this, goods and services are both any last but third line I'm reading in 11 subsection 1, from whole or part leviable thereon, with effect from a date as may be prescribed in such notification. So the option of notifying it from an earlier date is already there in 11 subsection 1. Next is about the description and HSN, because the wordings here says 11.1, 11.2 doesn't talk about HSN. It talks about description. So we'll read this again. Where the government is satisfied that it is necessary in the public interest so to do, it may, on the recommendation of the council by notification, exempt generally, either absolutely or subject to such conditions as may be prescribed therein, goods or services or both of any specified description from the whole or part of the tax leviable thereon, with effect from the date, such date as may be prescribed in such notification. So the reference in the notification is to the description. So the importance are the act speaks about the description. Now, how important is the description in the exemption notification for goods, in the exemption notification for services? how important is the classification HSN which is used in the exemption notification for goods, exemption notification of services. I have just tried to juxtapose. So this is the goods notification. This is the extract from the goods notification. There it says the goods notification, the second column after serial number is tariff item, subheading, heading and chapter, as we know. So here they say tariff item, subheading, heading and chapter shall mean respectively a tariff item, heading, shall mean, it says shall mean respectively a tariff item, heading, subheading and chapter as specified in the first schedule to the Customs Tariff Act. The rules of interpretation of the first schedule to the said Customs Tariff Act, including the sections and chapter notes and general explanatory notes of the first schedule so far as may be applied to the interpretation of this notification. So they say in this notification. So as we more or less very clearly, there is no doubt that it is entirely dependent on the customs tariff notification, right from the explanatory notes, the chapter notes, section notes, the schedules, all of it has to be taken from in the context of goods exemption notification. It has to be from the context of the Customs Tariff Act. When it comes to services, the explanation says reference to chapter, section, this is from 12, this is from I think 2. So reference to chapter, section, heading, wherever they may occur, unless the context otherwise requires, shall mean respectively as chapter, section and heading in the scheme of classification of service, which is an annexure to notification 11. And it goes on to say chapter, section, heading, group or service code mentioned in column 2. Column 2 is basically that HSN, the SAC, I mean 9985, 9967 are only indicative. So they say this is only indicative. So as if we just visualize the exemption notification, first is the serial number. Second, I'm referring only to the service exemption notification. First is the serial number. Second column is chapter, section, heading. Third column is description. Fourth column is the rate, which is nil everywhere. And there is no condition column in exemption notification. It is there only in the rate notification. So these are the columns. So they say the reference to understand the second column, chapter, section, heading, shall be dependent on the scheme of classification of services. So they do not, in fact, refer the column 3, which is description of service. And if we go to the next one, they say, even though here it appears there is some importance given to the chapter, section and heading, where they say you have to refer to the scheme of classification of service. But if you see the second explanation, the importance that it got in this stage has got diluted here to say chapter, section, heading, group or service code mentioned in column 2 of the table are only indicative. Which means to say, if we restrict it to the service notification, they say initially you refer the scheme of classification to understand the second column, that is the number 9985, 9963. And they further go on to say that it is only indicative, which I feel makes the relevance for column number 2 in service notification very diluted, as against the second column in the rate notification where there is no dilution. It clearly says you have to refer to the Customs Tariff Act. The reason why I am referring this so much because is we see a lot of advanced rulings, assessments, which are made by giving reference to the scheme of classification. So the entire discussion in the order is only because the scheme of classification, the entry in that annexure does not cover this particular description is what they say. But right from the beginning, not for this session, but right from the beginning, I was of a very strong view. I'm sure maybe a few more share the same thought. The description in 11 and 12 service notification is in many instances different when it comes to the description in the scheme of classification of services. Also, given the fact that the relevance of scheme of classification related entries is almost diluted with this entry in the notification, I really don't see any reason why we should go to the scheme of classification of service, number one. Number two, the entire discussion about a rate being applicable for a service or not, or about an exemption applicable for a service or not, in my view, has to be completely based on the description in the column 3 in the notification. The reason, of course, as it's clearly here, so it clearly says where the government is satisfied in the necessary, it is necessary in the public interest so to do, it may on the recommendation of the council by notification exempt generally either absolutely or subject to such conditions as may be prescribed goods and services or both of any specified description. So the determination of rate classification is based on the description in the context of service and not the other way around, not based on the SAC we arrive at the rate, it is based on the description that we arrive at the rate. Because we have seen many instances, and maybe if you may also come across this situation where the reference is too much given to the scheme of classification and the entry therein, even the circulars to interpret, if you recollect a circular which was issued in the context of oil exploration by the institutions, where the rate, whether there is a beneficial rate for oil exploration related activities where it is 12%, then the residuary entry of technical services which is 18%. There also the circular gives more importance to the scheme of classification related description. I believe the Act itself has not given, 11.1 specifically has not spoken anything about the scheme of classification, number one. And whatever is the entries in the scheme of classification, it is completely diluted with this entry in the service notification, service exemption notification 12/2017. So this is my thought on this. So maybe the final point on this before we go to the next slide is that the relevance of the scheme of classification is very minimal. And the next thing is the description in the notification, which has the blessing of section 11.1, will prevail over anything, is what I feel. Shall we pause or go to the next one?
Agreed.
Yeah.
Yeah.
Arupjit, 10:3, by till when we continue?
10:30. 10:30.
Yeah.
Yeah. So next is the basics of special exemption. That is the second one, 11.2. It talks about the exemption by special order. In each case, circumstances of special nature to be recorded in the order. To my knowledge, there is no notification issued, no order. I should not say notification because 11.2 is only order. There is no order issued under 11.2. I'll be glad if I'm corrected. Okay. So 11.2, if you see 11.1 versus 11.2, 11.1 speaks about exempt generally either absolutely or subject to such conditions, any specified description from whole or part of tax leviable thereon. So this clearly says, 11.1 clearly says the exemption could be whole or part. But if you read 11.2, though it is just for our academic interest, since there are no notifications which are orders which are issued under 11.2, here it says, where the government is satisfied that it is necessary in the public interest so to do, it may, on the recommendation of the council, by special order in each case, under circumstances of exceptional nature to be stated in the order, exempt from payment of tax any goods or services or both on which the tax is leviable. The reference to whole or part is not there in 11 subsection 2, but I was just reading this commentary by Justice Ramakrishnan Veera Raghavan, where I think he has brought out the point that if the exemption is given, if the power is there for prescribing a full exemption, it is implicit that the exemption could also be given partially. So going by that, though it is only for our academic interest, I think 11.2 should cover even a situation where the exemption, if they want to, they can give it by order, even a partial exemption, though the wordings are not specifically there when you compare 11.1 and 11.2.
Do we have any notifications for that? I don't think
Nothing, sir. No orders. Basically 11.1 is 11.2 is order, but I did not come across any orders. So next is interesting comparison between 11.3 and 168. So we'll read this again, 11.3. So the government may, if it considers necessary or expedient, so to do for the purpose of clarifying the scope of applicability of any notification issued under subsection 1 or order issued under subsection 2, insert an explanation in such notification or order, as the case may be, by notification to any as the case may be, by notification at any time within 1 year of the issue of the notification of subsection 1 or order under subsection 2, and every such explanation shall have an effect as if it had always been part of the first such notification or order, as the case may be. So we agree that they had a window of 1 year to clarify the applicability of a particular notification, and whatever they are doing it, it should be within 1 year, and it will have a retrospective understanding of that particular explanation, is what 11.3 has finally conveyed. So 11.3, the importance of 11.3, I feel, comes from the sunset clause of 1 year they give, because they have recognized that there should not be, I feel, again, I can be corrected as well, please. The essence, I feel, is that since they clearly want that ambiguity not to last beyond 1 year, any clarification that they wanted in the context of the exemptions or the notifications issued under 11.1 or order issued under 11.2 should essentially be given only within 1 year from the date of the issue of the notification, which is already over. But I was slightly interested to compare 11.3 versus section 168. We agree there are a lot of circulars issued even on the applicability or the interpretation of the exemption notification. So I was just trying to see what was restricted only for 1 year. Is it being achieved under section 168 eternally? So I have just tried to compare few things. Who issues the notification under 11.3? Government shall issue, and government will act under the secretary. So all the notifications that we see under 11 is under the secretary. When it comes to section 168, CBIC will issue, board will issue, and the board will act either under the commissioner or the joint secretary who is part of CBIC. So even if you see, the authority who can exercise this power under 11.3 is the government, and 168 is the delegated or the next level of government, which is CBIC. Purpose. So the purpose is for clarifying the scope or applicability of any notification issued under 11.1 or order issued under 11.2. But 168 is for the purpose of uniformity in implementation of the act. So even if you see here, the purpose of 11.3 is more specific and having more sanctity. 168 is in general to ensure the uniformity in the assessments being done by the field formations. To whom is this addressed to? This 11 subsection 3 is not addressed to anyone, as in it is saying the explanation will be part of the notification. So the power comes from 11, the Parent Act, and the addressing of 11.3 is by way of a explanation insertion in the notification itself. So it is going back to the act and the notification. But when it comes to 168, the section is addressing to the central tax officers for following the same. So this is more a subordinate order. It is more an order for the subordinates to follow under 168. Binding nature. 11.3, it is binding on everyone because that is what the act itself is. And 168 is binding on the department. Yes, we have Ratan melting and other things which are there. And if we see the last point, resort to. So if you can resort to 11.3 only for 11.1 and 11.2 within 1 year from the GST implementation, 168 is more generic to say any provision for implementation of the act. Now, my only point here is what was not possible to be achieved from the more sacred and more probably carrying more power by section 11.3, is it being achieved by section 168 by clarifying not just rate notification, but even not just the exemption notification, but even clarifying many entries on the tax notification, the rate notification? Because again, this goes back to the point that even the rate notification are issued also under the powers of section 11 subsection 1. If that corrects, probably if we can say that 11.1 is by reference applied to both 11 and 12 bar 2017, can we really look into a possibility of challenging the circulars issued under section 168 to have overreached the powers which was not otherwise reachable even by 11.3? So this is one thought that I had in mind, which I wanted to share. So that's what I just tried to, will the circular clarifying the scope of an exemption, the last wording, entry be invalid as it is indirectly exercising the powers under 11.3 under section 168, or for having exercised that power beyond the specified period under 11.3? So both the things. Is it overreaching and exercising the power? And what was not achievable in 1 year is being indirectly achieved by section 168 is one thought I think we really have to consider in case we are in litigation and we are looking at the possibility of challenging the clarification of any circular when it comes to rate notification and exemption notification. I know it is a double-edged sword. Many circulars are beneficial when it comes to section 168, but I feel maybe if you, without taking any sides or bias, I think this is one thing that we have to probably look at and compare to differentiate between the powers under 11.3 and section 168 on circulars. Any thought, anyone on this? Yeah.
Sir, isn't it 1 year from the notification and not 1 year from GST implementation?
1 second. It is. I'll open the provision. Okay, I think it is extracted here. Okay, yeah, I think yes, I stand corrected. So it is 1 year of the issue of the notification under subsection 11 and order under subsection 2, and every such explanation shall have the effect as if it had always been part of first such notification or order. Yes, I stand corrected. Yes, but still the issue remains. So any circular in that way, okay, it should not be circular, by the way. So I agree to the point of Uniji, but yes, it is basically the 1 year from the order or 1 year from the notification. But the question that still remains is what could not have been achieved by 11.3, can it be achieved by 168? So I leave this for everyone's discussion offline, considering the time. So 11.1 absolute exemption, if unconditional absolute exemption is given, either fully or partly, registered person not to collect the excess of the effective rate of tax. This we have already discussed. If it is not an absolute exemption, is there still scope for us to choose a higher rate? Strict and liberal interpretation. Now this discussion was coming up whether the exemption notification should be strictly interpreted. We have this judgment in the context of customs where they say if two views are possible, or there is no clarity in the exemption entry itself, then the benefit of doubt should go to the tax authorities. If there is any ambiguity in the charging section, benefit should go to the assessee. So charging section, benefit of doubt to the assessee, exemption notification, benefit of doubt to the department is what the Supreme Court has held in this particular case. But interestingly, there is one more case which we can further consider where they say you have to see the intent of the exemption notification. And your interpretation or leaning towards revenue or assessee should be based on that. This is again a Supreme Court judgment in 2021. So in terms of time, it is 2018. Here it is 2021. One must ask, what is the object that is sought to be achieved? Construe the statute in accordance with the subject. If an ambiguity arises in construction such ambiguity should be in the favor of exemption. This conclusion was taken after considering this discussion of this earlier Dilip Kumar case was also discussed in this, what was finally held is that objective of the exemption should be considered, and if it is to promote industry, granting incentive, economic growth, then the benefit of the doubt should be given to the person claiming the exemption, and it should not be to the strict interpretation, is what the Supreme Court has held in this Mother Superior Adoration Convent case. So probably, if you probably visualize the notification 12/2017, we can see that few notifications are considering the nature, are considering the type of activity. Probably in case if we can read that, we can probably think in that way. So the first thing maybe that example strikes to me is the notification where it talks about the exemption for 12AA entities by way of charitable activities. So since the exemption is entity specific, again, if we see the entire notification 12, there are 3-4 ways in which the exemptions could be there. One is the service specific, provider specific, receiver specific. It could be a combination of these. So probably all those where the exemption is specific to the recipient or the provider of service, can we say that those entries will have the benefit of a liberal interpretation and not a strict interpretation, and thereby the exemption should be allowed without reading between the lines or reading the wordings very strictly. So these two judgments, I think we can further discuss on these two judgments and compare, so that probably we can it will help our litigation in case if we are facing the denial of exemption, because after ITC the second most litigated even in the earlier context would be the exemption entries. So we will have to later more dwell into these two situations and see where we can apply this. Next is on which one should apply. So this I think I have already discussed. The one which is more beneficial, you can go. So one of the example is 12% and 5% if it is earthwork related. So I think there you can go for a beneficial one. And motor cab also, there are 2 entries. The one which is with the ITC in the same line of business, another is without ITC in the same line of business. So we can go for a beneficial one. And there are a few judgments which in fact allows you to choose between the options, the beneficial one. Existence of an exemption entry always vindicates levy. So this is again a question, just by the reason that there is an exemption, will it vindicate that levy is already there? So I think no, because if we have to categorize the entries, as I said, service provider specific, service receiver specific, provision specific, maybe one more category that we have to also look at is the entries which are given in the exemption notification only for the purpose of abundant caution. So I think, for example, this entry, service from person outside taxable territory to a person outside taxable territory, this is more for an abundant caution. It is not always vindicative of levy. So probably the classification or bucketing of entries into different categories is something which is relevant, I believe. So based on that, we can see if the existence of exemption is in fact a vindication of levy. So this we have already discussed. Can restaurant opt for a higher rate? I feel based on the reading and the reference of section 11.1 in the notification 11/17 is right, in spite of the fact that there is a condition which says that you have to go for 5%, because that condition I feel in a way is against the explanation coming after section 11 subsection 3. So the definition of exempt supply includes goods, services or both attracting nil rate, wholly exempt under section 11, and includes non-taxable supply. Non-taxable supply includes petrol, diesel. What about schedule 3? So I think you may agree that schedule 3 is no supply, so it will not be part of exempt supply also. And for various purposes of turnover determination or limit calculations, I think schedule 3 related entries should not apply. Only in the context of section 17, they have specifically said one of the entries in schedule 3, that is sale of building before completion, only that has a relevance to that extent. Otherwise, for the purpose of various limits and computations, even for declaring in 3B and 1, I believe schedule 3 entries are not part of exempt supply, thereby doesn't require an declaration. Only in the context of GSTR 9, where they say no supply includes everything. But that wording is not the same in GSTR 3B form. Scope of in relation to. There are about 12 instances where the notification 12/2017 uses the word in relation to. I think most of the cases around the 243W, 243G in the notification, not just now, even in the context of service tax, refers to the words in relation to the activities entrusted under to a panchayat under 243W. So how do we interpret this in relation to? We have Supreme Court judgments which says that in relation to has to be given a very wide meaning and not a restrictive meaning. So I think this is something which should again help us to read the exemption entries in those 12 instances where the word in relation to is used. Most of those 12, at least 8 to 9 of them, I think should be in relation to the government related services, especially the pure agency, pure service related thing. So I think there, I think it may have some relevance and help us in the point that we are trying to make. So this is what I had to share as my perspectives. I am open for debate and maybe also ready for any counter views that may be there from the audience. Thank you. Over to you, sir.
So I think the deliberation is wonderful, and we already had a lot of debates. In fact, on the partial and the absolute exemptions, I think it was a wonderful discussion that we had because a lot of issues and a lot of fronts were brought in. So there is one question by V.K. Chauhan, sir. Yeah. His question was that, say, if there is his question was, if I am selling exempt supply by charging tax, by mistake. So in that case, will the buyer get the benefit of the credit, ITC, whether he can get the ITC credit or not?
Sir, this part, I was reading a judgment in the context of earlier law, where it says that once you have accept that the tax, you should allow the input tax credit. But yeah, I think the wordings when it comes to claim of ITC in the GST provision is slightly different when it comes to in the context of earlier law. I have to say that I have to do a little more study to answer this, but anyone else has any thought on this, probably can share their thought on this. But I feel there are beneficial judgments, but the juxtaposition of those judgments to the context of GST is something which is to be analyzed from my side. Yeah.
I think Praveenji has raised this question. I think Praveenji, you want to answer this query, or you have a different question?
No, there is the questions or the situations which you are discussing.
Oh, Praveenji, we lost your voice.
Meantime, Arup, I will supplement to the Subbu. The credit will be available since the definition is says tax charge in invoice. It never says leviable or not leviable. So if something has been charged in the invoice, you should eligible to take the credit.
No, the question is for the person who is charging GST on an exempted supply, whether he will be eligible to take the credit. Now the issue whether you are supplying taxable goods 12% rate, you are charged 18%, whether the recipient is eligible for credit. I think yes, because as you rightly said, ITC is basically not the tax charged, but the tax levied, but it is the tax charged. I think we have Supreme Court judgment even in surveys refractories, and even we have in the context of central excise few circulars where it says that charged is what is important. You need not get into the classification. But I think the question is more from the supplier side. When the exemption is there, can he claim the credit? Okay, recipient is eligible to avail credit. So sorry, I misread the question. So I think yes, you have answered, Nilesh ji, you have answered the question. Rightly said. So since the tax charged is relevant for the recipient to take the credit, yes, it is available. I read the question as, so let us say I am doing an exempted service, but I have charged a tax on that. Can I claim the credit? So I thought the question was that, for which I had to do a reading. But yes, the question I just read it again for benefit of everyone. If the registered taxable person charges tax on exempt supply by mistake, will the recipient be eligible to avail the ITC? My answer is also yes. I concur with Nilesh ji.
Yeah. Now coming to the other question that you had raised, what happens to that actually? That is also another important area. That is, I'm not supposed to charge tax, but I've charged tax and availed ITC as a supplier. So in that case, I think availing the ITC would be a huge challenge.
That's right, sir. It will be a challenge, but yes, I feel there the issue that they may raise is something which is most important. I feel maybe I have to do a little reading before I actually answer this. But yes, to my immediate understanding, if the notice say is issued to deny the credit, or is the notice issued to say that you have collected a tax where it is not applicable, should probably give a hint for us to probably choose the appropriate way of litigation or response, I believe. But yes, there are few judgments which says that once the government has accepted the tax, they can't deny the credit. So the point goes back to the issue that is raised. Are they demanding, saying that you have collected something as tax?
No, I'm fighting a show cause notice on this. Okay. What they are saying is that they have gone to section 17.2. And they are saying that as per section 17.2, you have to reverse on the exempt supply. And this is an exempt supply. Okay. Right. So how so
I think this more clearly gets covered in that. So this is very clear. I feel they have one way accepted that particular tax.
Yeah.
And so I think what you may immediately do is apply for a refund, sir, whatever you have paid.
No, refund time is gone. So now we are refunding.
It should apply, right, sir? So I think refund time, I feel it should still be there, but the only issue there is unjust enrichment should be an issue. Yes.
No, I am fighting the same case over here. Most of the government departments in Kerala chose to collect taxes on services as well as goods and claim ITC as a matter of abundant caution. Now, DGJ has issued notices saying that whatever you have collected is under 76 and all your ITC should be reversed and repaid back in cash.
So both should not work, I believe. You also demand the output tax and you also deny the ITC. So that is what I think. I'll share the judgment which I have noted in the group offline, where it is there, I think, or you may already be knowing, Uniji.
Yeah, then I think we'll go to Praveen ji. He had some query. Praveen ji.
No, I was just like to add one argument in relation to mandatory lower rate, because these were the issues raised in determination of valuation rules in works contract. And as we know that intention behind the law has to be read. From there, they have learned the situations and they have put up a condition. So intention behind the law is not to allow credit and to allow allow you to charge the full rate and allow you the credit for ITC, what you discussed earlier in earlier part of your presentation. So intention behind of the law is not to allow credit and to allow and to charge output tax at lower rate. This is being drawn from determination of valuation rules wherein credit of input tax material was not allowed. And people were contesting that I don't want to have the benefit of lower rate. I will charge full rate and avail the credit of inputs also, which they have lost the case. Means that option was now intentionally divided in GST. So that line has to be tested whether conditions per se are mandatory or not.
Right.
Agreed,
so
possible, sir.
I think as we are closing down on the time and we try to close on time, so I would request all the other group members. First of all, I would like to thank each one of you for joining in. Though Unniji will be giving the formal vote of thanks, Unniji already. So I would request all the group members to put in their queries in the group, because Subbuji is there in the group. He will respond to all your queries. In the meantime, we have seen some citations being given in the group chat, like vegetable products and Mother Superior, Dilip Kumar. So I would request one of the group, maybe Padmaji is here. He can share all the, Padmaji, you are here. So if we can share all the judgments in the group, because we had the discussion. So all the judgments in the group, it will help to deepen our study on section 11 and the exemptions. So with this, I would request Unniji to give a formal vote of thanks. I think Unniji is having some network issue. Venu ji, are you here?
Yes, yes. I got an opportunity.
Yeah.
मैं wait कर रहा था मेरा नाम लो So firstly, Subbu, thank you for taking up this topic. Having speakers is very important. And second, so there is like it is also an opportunity for all of us to rethink, such as though short provision, but rethink how it has been ordered, the notifications that are being issued, the relevance of using those section numbers. All those things are definitely important. And for I would not say expert, but at least for the senior GST consultants, all like us, it's very evident that anything that comes up, we have to go deeper. And as Arupji rightly said, all those case laws are relevant for us to go through it in detail. So special thanks to Subbu for taking the session and making us to think, pause on this small section. Thank you, Subbu.
Thank you, sir. Thank you very much. We are really grateful to organizers for having this done continuously. So thank you all the participants for a patient listening. So we can of course connect offline, which we are always doing.
Yeah. And thanks to
one note,
yeah.
one small note. All of us in the group, make your request to other group members whom you know to participate. See, the advantage is we will get a different set of questions when we participate, and which will help others also to think, including for the speaker, we will also get a new perspective. So large participation is very much required.
Yes.
We'll
And
be
next
forced
week-
to introduce CP.
Yes. Puni is trying hard to get a CP for this.
We need to speak of this. Yeah. So thank you and wish you all a wonderful Diwali, happy Diwali. And so next Saturday we'll be meeting on I think section 10. Okay, because there was some conflict of dates because Subbuji had some other preoccupation next week. So we swapped the dates. Today we are having 11 and next Saturday we'll be having section 10. So Vishal Poddarji from Nasik, he will be taking the session. So we request all of you to join and have a wonderful week ahead. You know, for some part of India, it's a long weekend, so extended weekend. So thank you very much, and let's keep on learning.
Thank you, sir. Thank you.
Thank you.
Thank you. Bye.
Thank you.
Happy Diwali. Thank you.
Happy.
Thank you.
Happy Diwali all.
Happy.